from my side, the guy intro.
Okay. Uh, we are live.
Hello, everyone, and welcome to today's webinar on company director changes. My name is Simon Fenyani, and I'll be facilitator for today's program. Our presenter, Thomas Levete, is a manager, is from the directors, members, and authorized representative unit. The presentation will be followed with a question and answer session. During the webinar, you are welcome to post questions related to today's topic under comments. We will respond to these questions. If you have questions that are not related to the topics, please log an inquiry on the CIPC website inquiry system or send a message on CIPC Facebook with a messenger. The recording of this webinar will remain on Facebook and YouTube should you wish to view it again. I now hand over to Mr. Levete for his presentation. Thank you.
A very good morning to you. My name is Mashudu Thomas Levete. I'll be doing the presentation on the director changes. And then I hope that by the end of this presentation, you will be able to understand what are expected from you whenever you want to file the change of company directors. So you will have to ask questions later on that I will try by all means to respond to the best of my knowledge. So maybe we can move now with the presentation. Ruzani?
Okay. Yeah.
Yeah, just move the slides, please.
Yeah, moved.
No.
It's not moving.
No. And can you also enlarge the screen, please, if possible?
Okay, let me do this. Can you see it?
Yeah, I can see that.
Can I see the second page?
Yes, I can see that.
And there's a mandate.
Yeah, then we have to start here.
Okay.
Thank you. Yeah, colleagues, CIPC is mandated to change company directors in line with the requirements of certain sections within the Companies Act. So here I have selected some few sections that plays a vital role whenever we do the company change. So we will touch some of these sections along the presentation so that you can have a clear understanding as to how this is applied whenever we have received the applications. We will touch mostly on the section 70, which deal with the vacancies on the board of directors, also the removal of directors, which is one of the main issues that we normally process on a daily basis. And then we'll also have to look on the Regulation 39, the directors and register of persons disqualified from serving as the director. So these are some of the topics that I will touch along the way of the presentation. So when we come to the resignation and appointment of a directors, you will remember that the company is in operation, it has got directors, and then there comes a time where they decide to change the company directors based on the resignation of the directors, which need to be replaced, and then also due to the incapacitation of the director, whereby the director is very ill and then cannot be able to run the day-to-day activities of the company, or it can be due to the death of a director or the expiry of term of office, or the director has retired. So these are the opportunities whereby they can arise within the company, so that the vacancies arise that need to be filled by filing the CR39 application within 10 business days after the director has been appointed or the director has resigned. So when the director resigned from the company, he need to hand over the resignation letter to the company, or if it's a newly appointed director, he needs to accept or give consent to accept the appointment as the director of the company. And then from there, we will also need the minutes of the meeting or the resolution taken by the company to change the directors. And then they must also submit the form with the resolution or minutes. And then what is very much critical here is that when the director has resigned, you don't need to indicate that the director has been removed. Or if maybe the director has been removed, you don't need to say the director has resigned. So it must be resignation on the form and also resignation on the resolution. Or it must be the removal on the form itself, the CR39, as well as the removal on the resolution. So the resolution and the form must talk to each other. We don't want to have conflicting information. So when you complete the application, you need to bear in mind that the information that you provide on the form should also be reflected on the resolution or the minutes of the meeting, just to let us know that this is the change that need to take place. Then we can move to the next one. So when you find yourself in a situation whereby there is a vacancy, you will have to select how you want to transact with CIPC. We give you 3 options here, where you can decide to file your application manually, or you can file your application on e-services, or you can upload the document on the website. So when you file the manual application, make certain that you send that to the manual email address. And then if you have done it electronically, you must also send it to e-services email address. Maybe Rosani moved a little bit quicker because you need to see the emails that you need to send the documents to on the previous slide. If you can go back a little bit, Rosani, so that they can see the email address where they have to submit the documents. So the manual application must be sent to manualcr39@cipc.co.za, and the e-services application should be sent to e-servicescr39@cipc.co.za. So if you upload the document, then you will have to go to our website, and then you log in as a customer, and then you go to transact, and then from there you will get the selection. That is where you will get to go and select the uploading of the document. Then you upload your document on the website, and then it will come through for processing. So these are the 3 channels that you may choose whenever you want to file the change of company directors. So when you submit the application, there are certain supporting documents that need to come with the CR39. So for both manual and e-services transactions, we will need the minute of the meeting or the resolution that has been taken, whereby directors have agreed to appoint a director or they have agreed to accept the resignation of the director. So we will also need the minutes of meeting that has been signed by all directors as required by the practice notice number 1 of 2019. Sometimes people do the round robin resolution, which means that there is no formal meeting that took place, but the directors have agreed it can be over telephonically that this is the change that they want to make. So that is a round robin resolution. It is not a resolution that has been taken in a formal meeting, but each and every director is aware of the change that is about to happen. So when they submit the round robin resolution, they just need to indicate that no meeting took place. The resolution was taken by a round robin resolution so that we can be able to see this is how the decision was taken to change the directors. We will also need the certified ID copies of all directors who are affected by the change, which means that for those directors who are resigning, we will need the ID copies of them. For those directors who are being appointed, we will need the ID copies of those directors. For the remaining directors, we don't need the ID copies, which means if the company has got 2 directors and then now they want to appoint 1 director, and then we will only need the ID copy of that incoming director. If there is somebody who is resigning, then we will also need the ID copy of that person. So we will also need the certified ID copy of the applicant. This is only required in case the company has requested the third person to file the application on its behalf. But if the transaction is being filed by the directors themselves, then we don't need the ID copy of the applicant. So this is only required so that we can be satisfied that the person who filed the application was authorized by the company to file that application. And then in case of the deceased director, we will need the death certificate to prove that that person is no more. So you will remember that on a close corporation, if maybe I can touch on that one a little bit, even though it's not part of the presentation. On the close corporation side, we normally require the executorship letter in case the member has passed on. The reason being that in a CC, the person or the member has got interest in the CC. You are a member by virtue of having a certain percentage because you have contributed something in the business, and then you become a member who owns a certain percentage. Maybe you own 10% or 20% or whatever the percentage might be. So when you passed on, then an executor need to be appointed to come and manage the estate of that person. So that is the reason why we will need the executorship letter that is normally issued by the Master of High Court, so that that person will come and manage the estate of the person. Whatever that need to be signed will be signed by that person on behalf of the deceased member, because the person who passed on owns certain percentage within the business. So when it comes to a company is normally owned by the shareholders, and then the directors are just employees of the company. So whenever the director passed on, he don't have any interest within the business. He's just an employee because he has been employed by the shareholders to come and work in the company. So if he passed on, then we will need the death certificate so that we can be certified that this person now has passed on. So I think I've made a little bit clear the difference between the close corporation as well as the death of the company director. So appointment letter will be required, and the resignation letter will also be required. This, in the past, we used to accept only the resolution or minutes of the meeting whereby they tell us that we have appointed director AB, and then we have also resigned. Maybe the director ABC has resigned. We were satisfied with that information in the past, but we get a lot of complaints whereby a director, we will receive the resolution that he resigned, but After we have resigned that person come back and say, no, but I never signed any documentation to confirm that I have resigned as a director. So it's then that we decided to close that hole by requesting that whenever there is an appointment of a director, a consent letter need to be submitted to confirm that that person accepted that position, as well as if the person has resigned, we need to get the resignation letter so that even if he can come back, then we can produce the letter to show that this is the letter that you have signed to confirm that you have resigned as a director. So these are the requirements that we normally need whenever you file the application to change the company directors. So if some of the information here is missing, then the application will be rejected, and then they will tell you the reason why your application was not approved. But if you have complied with everything that I've indicated here, the application will be approved and the certificate will be issued with the updated directors. So we can move to the next one. This is the manual application form that you will fill. Maybe some of you are not familiar with the document, but this is how it looks like. You are going to fill in the information as required by the notes indicated on the first page. And then from there, you will move to the next page whereby you will complete the details of other directors using the notes on the first page. But the most important thing on the form is to complete the customer code on top, because the customer code is linked to the email address whereby we are going to give you feedback about your application. So by completing the customer code, then we know that when we respond or after we have processed the application, the response will be sent to this email address. So if there is no customer code on the form, then the application will automatically be rejected. We cannot take it. So this is the form that you need to complete. And then after you have completed, you will attach the documents that I've indicated in the previous slide. And then you will have to use the email address that I've shown you, which is manualcor39@cipc.co.za. Then you send the information to that email address, and then we will receive that document for processing. The next slide is still talking about the manual application, whereby this is the email address that you need to send. Once we receive the application, we allocate the tracking number within the office. So after we have issued the tracking number, like I've indicated on top there, then the documents will be packed in boxes, and then from there they are distributed to the officials who are going to process them. And then now they are going to manually capture all the changes that you have highlighted. And then once they are done, the outcome or the certificate or a query of that application will be dispatched to the email address linked to the customer code on the form. As I have indicated, that the customer code is very much important. Without having the customer code, you cannot be able to transact with CIPC, so your application will automatically be rejected. So by completing the customer code, we know how we are going to communicate with you at the end of the process of your application. Then you can move. We also have the e-services transaction. This transaction is handled by the customer. The customer will go to CIPC website, then you'll go and log in using your customer code and the password. And then from there, you will go to transact on the top of the screen, and then it will give you the options. Then you will have to go and select the second option that deal with the change of company directors. From there, you will go through all the steps. You capture all the changes on the website. And then once you are done, the CIPC will send you the form that you have captured with all the changes that you have made. They will appear on the form, and then that form will come with the tracking number on top. The tracking number, it will start with 93 on top there. That is the tracking number of your application. So when you file the application, And then you need to reflect that tracking number on the subject field of your email, because the system has been designed to read only tracking number. If you put registration number of the company, then the system will not be able to read that registration number, and then the application will automatically be rejected. So you only need to write the number. Don't start by writing tracking number in words and then from there you come and write the numbers. No, you need to write the numbers straight. If it's 9345667, you just write it exactly the way it is. And then from there, when you submit the application, then the application will go through. So, Rosani, now, yeah. After we have examined the application, because we will have to look whether you have complied with all the requirements, you submitted all the supporting documents that we need. If there is a new appointment, we find that the minutes of the meeting confirm that. The consent letter to accept the appointment is also there. If there is a resignation, then we also need to get the resignation letter. And then if everything is there, then we just click approve, and then the system automatically generates the certificate and dispatch it to the email address that is linked to the customer code that you have used when you log in. So the customer code is very much important. Even on the e-services transaction, then it also plays a role. So once you have done so, CIPC will release the certificate and then send it through to you. And then that is the end of the process. So you can see that this is the most convenient process, because it's quick, and then everything is captured by the client. CIPC only verify the compliance of the application, and then from there they just approve or reject. If they reject the application, they will indicate the reasons why the application was rejected. And the most important thing is that once the application is rejected, when you have to refile, don't use the very same tracking number that has been rejected, because the system has already read that tracking number and then release it on query. So when you resubmit it, the system will not be able to take it for the second time. So you need to do a brand new transaction whereby a new tracking number will be issued, and then you will have to attach all the supporting documents, including the one that was previously omitted, and then you refile the application for processing. I think that is much clear. Then I will just show you the steps in the next slide on the screen that you will see. When you log in there, you will go and click on the customer login, and then where the system will require you to put in the customer code and the password. And then from there, you will move to the next page where it will show you transact on top. You will click there. The moment you click transact, you will get this screen. This screen now will show you, that is where you are going to make a selection of what you want to do. Then you will go to the next option, which is for director, amendment of director details. And then you will click on that option. After you have clicked, then you'll get this page whereby now you are going to insert the company registration number. And then the company registration number should be captured correctly. Otherwise, you won't be able to proceed from this page if the registration number is captured incorrectly. So the moment you put in the registration number, let's move to the next slide. It will show you how the registration number is captured. It should be like this. Then it starts with the year followed by 6-digit numbers. At the end, then it will be the description of the company. 07, it's a private company. If it ends with 23, it means it's a closed corporation. So it will depend on what type of business are you trying to make changes on. Then after that, you'll just go down and click on the next slide that will show add new director. If you want to add a new director, then you will come and click here. And then from there, it will give you the next page, whereby now you are going to capture the details of that new director. That is how it will look like. You will go down this page, capture all the information as requested. From there, at the end of the process, then you click save. Once you click save, it means that you have captured everything, it's complete, and then CIPC will now send you a page, a CR39 form with the tracking number that I've talked about, that you need to sign. And then after you have signed the document, it needs to be signed by at least one director. Not everyone should sign. At least one director can sign the form. And then once the form has been signed, then you will attach the supporting documents that I have indicated previously. You can scan them together, and then you email everything to eservices cor39@cipc.co.za. And then don't forget to quote tracking number on the subject field of the email, because that one is very much important. If you don't put in the tracking number, the application will not come through to us. So you need to put the correct tracking number so that the system can automatically send the document to our processing queue. Then your application will then be processed, and then the outcome will be given to you, whether it's a certificate or a query. Then we can move to the removal of a director. The removal and resignation is not the same thing in terms of Companies Act. We normally come across the application whereby people mix removal and resignation on the form. So the director can be removed in terms of Companies Section 71. That is where they explain everything, how the director is removed. And then the director can also resign due to personal reasons. So the resignation and the removal, so it is not the same thing. So a director can be removed by the board or can be removed by the shareholders. Because when we come to the removal of a director, Section 71, it provides two options for removing a director. Firstly, by an ordinary resolution adopted at the shareholders meeting of the shareholders of the company, then they can decide to remove a director in the ordinary as an ordinary resolution within that meeting. So secondly, the director can be removed by the board of directors. So these are the two options that need to be followed whenever the director has to be removed as a director of the company. It's either by the ordinary resolution adopted at the shareholders meeting of the company or by the resolution of the board of directors. So these are the two options that the company should choose whenever they decide to remove a director. So a director may be removed by the board of shareholders, as I've already indicated. Sometimes the director has committed misconduct, such as theft, fraud, or whatever reason. So the shareholders feel that, no, we cannot keep this director. We need to remove him. Then they can follow the process under Section 71 so that the person can be removed as a director of the company. So the application and resolution must have the same information as I've already indicated, that the removal on the form should also be the case on the resolution. If it's a resignation on the form, it must also be resignation on the resolution of minutes of the meeting. And then a notice must be sent to the affected director with reasons for removal to enable that person to prepare a response, which means that if the company decides to remove a director, that person firstly need to get a notice of the meeting, that a meeting is going to be held on this date, at this venue, at this time. That is where we are going to vote you out as a director because you have committed 1, 2, 3. So the reasons for the removal must also be highlighted in the notice when it is issued to the affected director, so that that person can be able to prepare the response on the proposed date of the meeting. Because it will be unfair to call a person to the meeting without knowing why he is supposed to be, without knowing the reasons of his removal. And then when he gets there, he gets a shock of his life that we are going to remove you because you have done one, two, three. And then you find that those allegations are unfounded. So he need to be given a time to prepare a response on the date of the meeting, so that on the day of the meeting, he can come and do presentation himself, or he can come with a representative who can come and represent him in the meeting before the resolution is put to a vote, which means that after the presentation has been done, then the shareholders will have to vote as to whether the director provided fair reasons that will warrant the removal or not. Then they will have to vote for his removal. And then you can also refer more information on the practice notice number 74 of 2018. The notices are available on our website. Then we also have the objection of an unauthorized transaction. So we do registrations on a daily basis, and then we get a lot of complaints whereby people complain that I just find that I've been removed from my company without my knowledge. I didn't authorize anyone to remove me as a director of my company. So I just want to find out what happened. What is the remedy from CIPC if maybe I have been unlawfully removed from the company? So we have the regulation 168 in the Companies Act, whereby the person is required to file COR 168 form as an objection of the transaction that took place. Then you will have to indicate on the objection that this transaction that happened under this tracking number, or maybe that happened during this time, it was unlawful and then it need to be reversed. So in this case, such transaction, once we receive the COR 168, we will reverse that transaction and put it back to where it was before COR 39 was submitted. So it happens that you picked up that there is an unlawful change of directors after the 10 days period has passed. And then you find that you don't know what to do. So the remedy that is available, once you picked up that the change of directors has been done more than 10 days ago, then you will have to file the manual COR 39 that I have showed you in the previous slide. You will complete that manual COR 39. At the bottom of each block, it shows the nature of change. That is where you put the status of that person. So you will complete the details of all the directors, including the one that was unlawfully appointed. And then at the bottom, you will just indicate remove unauthorized appointment. And then if maybe there was an appointment that was not, I mean, the resignation that was unlawful, then you will just indicate under the details of that person who has been removed or resigned, you will indicate reinstate unauthorized resignation. So remember that once we get that information, especially when it comes to the removal of the director who was unlawfully appointed, you don't have to follow Section 71 processes, because we cannot expect you to invite the person to come to the meeting whereby you are going to vote for his removal, because that person in the first place was unlawfully appointed. So you don't have to go through the pain of contacting that person, because sometimes you find you don't even know that person. The company has been hijacked by unknown people. So we cannot expect you to convene a meeting with the fraudsters so that they can come and then you vote them out as the directors. So by filling the COR 39 manual form and indicate this is an authorized appointment and then this director must be removed, then we know that this removal is not in line with Section 71 of Companies Act. Then we will have to use the manual CR 39 to remove that person. What you need to provide us is just a resolution signed by the authorized directors explaining what happened, and then they also attach the certified ID copy of the complainants so that we will be satisfied that these are the people who are complaining. This is the resolution that they have taken to remove these people. And then from our side, we will just process the application and then remove those directors from CIPC records. And then the company will be taken back to where it was before the filing of that transaction. Then we can move. We also have the disqualification of a director. So directors are being disqualified, which means that they are no longer permitted to act as company directors. So, but the court is the one that can declare a person to be disqualified, which means that that person is a delinquent director. So the court may disqualify that person on the grounds of misconduct involving dishonesty, or maybe that person has been convicted in any court of law for theft or for fraud or for whatever reason. So once the person has been declared to be disqualified, the court will have to send the court order to CIPC, because CIPC has got a register for all disqualified directors. Then once we receive the court order, we'll just have to record that person in the register of disqualified directors, which means that that person will not be able to be appointed as a director of the company. Because whenever you try to put the ID of that person on the CIPC website, it will automatically show you that this person is disqualified, which means that he is not supposed to be appointed as a director. And then normally disqualification, in some instances, it can take between 5 and 10 years. So, which means that after you have served that period, that person can now be qualified again to be appointed as a director. But before we can remove that person from our register of disqualified directors, we need to get a court order that will tell CIPC that this person has now fully rehabilitated, and then he can now be appointed as a director. Then we will remove that person from the list of disqualified directors. And then from there, that person can now be appointed to act as a director of the company. But during the period of disqualification, that person must not be appointed by any company, must not be elected as a director of a company, or he must not consent to be appointed or elected as a director of a company. Sometimes you find that the company do the head hunting skills outside in the market, even though they know that this person is a guru in a certain area, maybe in financial management, even though they know that this person is very good, but he has been disqualified, they don't have to appoint that person to come and act as a director. Because even if they try to appoint him, then they won't be able to register him as a director of the company, because the moment we key in the ID number of that person, the system will automatically reject that person until such time when the person is rehabilitated, and then we have received the court order. Then that person will be removed from the list of disqualified director, and then now he will be permitted to be appointed as the director of any company of his choice. Then here is the processing period that we have, so that whenever you submit the application, you don't have to submit and then wait forever. So we have got the time frame, which are the service delivery standards within CIPC. For the manual applications, it will take 3 business days to finalize the application. For the e-services application, it will take 2 business days as the turnaround time. And then we normally encourage customers to file online, because this is much quicker and more convenient, and then it eliminates a lot of errors as compared to the manual transaction. Because sometimes you give us the information, and then when people do the typing, sometimes there is some human errors, then they type something incorrectly, and then when you receive the certificate is wrong. And then maybe, for example, on the surname was spelled incorrectly, or the 1-digit number on the ID number, it's omitted. And then when you take the certificate to the bank and then they said, no, they cannot assist you because the information doesn't correspond with the original identification of you. So if you have captured the information yourself, you are 100% sure that you have captured everything correctly. And then what CIPC is going to do on the e-services transaction is to check the compliance and then also approve the application. And then the certificate is generated to the email address that has been linked to the customer code that you have used when you log in for that e-services transaction. So these are the turnaround times. And then here followed by the practice notices that are also available on their website. It's a lot of practice notices that I cannot go through each one of them, but I just put them here so that you can be able to see that we have got such kind of notices that can also assist you to file the application, because they will guide you that this is what you need to do, this is what you don't have to do. As I've indicated in the beginning, that we are processing the application based on the Companies Act and the practice notices that are approved by the commissioner. So these are the practice notices that you can browse through on the website so that they can guide you when you want to file the application. So I think that is the end of my presentation.
Thank you very much, Mr. Mashutu, for this presentation. And then we will now start with our questions and answer session. Yes, thank you, Rosani. Can we now start with questions? We have a question here that good morning. Where can we find the presentation slides? Thank you very much. We posted on the chat. You may request a copy of this presentation at education@cipc.co.za. Thank you.
And then just to add on what Simon is saying, it will be on the website and webinars, the presentation and the video will be posted just after the webinar.
Thank you very much. Let's now start with our questions, and then yeah.
So I see the question here that says, what happens in the instance when a director is removed and then he fails to provide his ID? Yeah, in a normal situation, remember, when the director is being removed, it means that he has done something wrong, and then he will not cooperate at all. So he may decide not to hand over his ID copy. So what you need to do is just to provide an affidavit stating the reasons why you cannot provide the ID copy of that person. Then that one will be accepted.
Thank you very much, Thomas. The next question says, good day. How now it's gone. Good day. How do I remove a member of a trust corporation that doesn't have estate or a executor and no testament? We have submitted a letter of the court, but CIPC keeps on declining it. Thank you, Tommy.
A member, as I've indicated, because that person owns interest in the business. Once he passed on, an executor need to be appointed by the Master of High Court to manage the estate of that person. So there is no way that once the person has passed on, we just get somebody who is not authorized by the court to act on behalf of the deceased.
Thank you. Another question it says, does the minute or resolution need to be certified?
No, you don't need to certify the resolution or minutes. What you can certify is the share register certificate of the company.
And then the next question is that, do the directors need to agree to accept a resignation? This does not sound correct.
Yes, remember when the director decide to resign, so you cannot force that person to remain as a director. If he handed over the resignation, it means that he is pulling out of the company. He is no longer interested to be a director of the company. Then what the company need to do is to file the necessary documents to CIPC so that that person can be removed from the records of the company.
Thank you.
How
And
can I
then
remove the director that has passed away? Yeah, this one it's a tough one whereby a person has passed on and then the family refuses to provide a death certificate, and then unfortunately CIPC cannot remove a person without a death certificate. Maybe as a proposal, I'm not quite sure. Maybe as a proposal, you can contact Home Affairs with this inquiry so that maybe they can see how they can assist you. Because at CIPC, we will need the death certificate of that director.
next question. Good day. I would like just to find out, why is it not allowed to use a temporary ID from
So,
Home Affairs to the director changes or do a resignation with it? Do a resignation with it. Thank you, Tommy.
no, the temporary ID can be accepted because remember on the temporary ID, there is ID number and the person's ID copy. I mean, the person's ID, person's photo on that document, and then it has been issued by Home Affairs. So that one we know that you have currently the original ID copy, but we can use the temporary document for time being.
Next question. Does
A
the
company
appointed company
secretary is not necessarily the appointed company secretary doesn't have to submit the applicant ID because that person is part of the company.
next, Tommy?
Your processes required me to submit all the IDs of the remaining directors as well as one of our directors resign. So as I've indicated, we need the ID copies of only those directors who are affected by the change. So if maybe you receive a query that requires the ID copies of everyone, that query is wrong. Then you can just return that query back to CIPC because it was not supposed to be rejected like that.
Next question.
The process of changing directors. As I've indicated, we will need the CR39 form. We will need the minutes of the meeting or resolution confirming the change of directors. We will need certified ID copies of the directors who are affected by the change. And then we will also need the consent letter in case of the new appointment, as well as the resignation letter in case of the resigned director.
Next question, Thomas.
For a deceased director in a PTY, in addition to the death certificate, we were told to provide letters and the exit. What is the difference now? Okay, this one, I just want to make this one very clear. This question is very much important because this is a situation whereby the company has got one director who is also the sole shareholder. And then it happens that that person passed on. Once that person died, then it means that there is no one who is going to manage the business. So in this case, an executor needs to be appointed to come and manage the estate of the deceased. That is where now the executorship letter is required in case the director has passed on, because there is no one left in the company. So unless if maybe by the time the director dies, maybe in the will he has specified the executors. The Master of High Court will have to issue letter of executorship to the person who has been appointed as executor by the deceased while he was still alive. And then they will issue the letter so that that person can now come and manage the estate of the deceased. That is where now he is also expected to appoint the directors who will continue with the day-to-day running of the business.
Thank you, Tommy. The next question.
Is the resolution, if there is round robin via telephone, do all directors have to sign? Now, in this case, they don't have to sign as long as they have indicated in the resolution that this is the round robin resolution. We know that they have taken the resolution through telephonically or maybe by emails or whatever means, but it was not in a formal meeting. Then we don't expect them to sign the documentation.
Next question. Does the death certificate need to be certified?
The death certificate normally is certified at Home Affairs. It comes out with the stamp from Home Affairs to confirm that the person is deceased.
Thank you. Next question is a comment and a question at the same time. That
Yeah,
yeah, certified IDs of
yeah,
all
no, this one,
directors. Yeah.
no, this one is wrong. If maybe you get this kind of a query, you are welcome to direct it back to me to correct that, because you are not expected to submit ID copies of all directors. We only need ID copies of those directors who are coming in and those who are going out of the company. For the remaining directors, no ID copies are required.
Next question.
Now, for the deceased, the director, we don't need resignation letter, because remember that this person is not resigning. He has passed on. So we only need the death certificate to confirm that he is no more. He is not resigning. He is deceased.
Do you have any idea of the MOI? How to
No,
be?
this one, I don't have an idea because it is not within our unit. I think it's
Yeah.
at the other department.
Okay. We'll request you to send us this question on the education at cipc.co, and then we'll direct it to the relevant division and then they will respond to it. Thank you.
Okay, thank you.
Next question.
What do you do when you don't have the death certificate of a director? Yeah, as I've indicated that you can approach Home Affairs. Maybe they can assist you with the death certificate, because the death certificate is required at CIPC. We cannot record a person as deceased without having a proof of a death certificate, because we can record later on that person appears and then he said, I am alive, I never passed on. Then what are we going to say?
Next question.
How can a director remove other directors who are overseas and who have made no contact with any of those directors are not to be contacted? Yeah, in this case, whereby the directors are nowhere to be found, and then they are not taking any active role in the day-to-day running of the company, and then maybe sometimes they are blocking the progress of the company, then the company can pass a resolution to remove those people. On the resolution, they will indicate the reasons why they want to remove them. And then they will also need to provide us with an affidavit stating the reasons why they cannot provide the ID copies of those people. Then we can be able to assist in that regard.
Next question, Tommy.
For a CC, does the executive have to provide their ID also? And do they need to sign the minute resolution? Do they need to provide a mandate to agent submitting the change? I'm not quite sure here whether the client is referring to a change of a CC or a company, but as it is here, it looks like it's for a CC, whether the executor does have to provide their IDs also. The person need to, the executorship letter will come with the names of that person, and then the ID copy can also be attached to support the executorship letter on a CC.
Next question.
My CR39 submitted last week was declared that it requested the share certificate of the new as the order person the new supporting document that needs to be attached. Okay, where we requested the share register certificate, it's in a case where the resolution has been taken by the shareholders. If the resolution has been taken by the shareholders, we will request the share register certificate, because at CIPC, we don't have a record of the shareholders of a company. So we only have the record of the board of directors. So if the resolution has been taken by the shareholders, you need to give us the share register certificate to prove that these are the shareholders who took this resolution. But if the resolution has been taken by the board of directors, we will only need the attendance register of those board members who were present in the meeting.
Thank you. And then my father passed on in February, and I was a sole director, shareholder. We now want my youngest brother to take over, but they claim to want an executorship letter. Why is it that?
So if the father passed on in February as a shareholder, and then now they want the younger brother to take over, obviously, who is going to appoint that person? Because the moment the sole shareholder passed on, an executor need to be appointed to come and manage the estate of the deceased. That executor is the one who got the responsibility to appoint the new directors. So the new director cannot just appoint himself because the business is for his late father. There must be an executor who will come and manage the estate of the deceased and also appoint that person as the new director who will take over the company.
Thank you. Next question. If you have a letter of consent from the director who is being appointed, why does CIPC sometimes also require the new director to sign the resolution?
Yeah, remember, if the director has been appointed and submitted the consent letter, it is not necessarily uh, required for that person to come and sign the resolution, because sometimes he was not part of the meeting, but he has been appointed as a new director. So we cannot expect that person to come and sign the resolution if the resolution has been taken by the company to appoint him. Whoever is remaining in the company or the member who are currently active in the business are the ones who are expected to sign the resolution, not the new director who is coming in.
Then, good morning, everyone. Are there alternatives that are available to effect directorship change when directors are not submitting the documents and details that are required by CIPC?
So if the company, if they have lodged the documents, and then we find that the documents, the application doesn't comply with all the requirements that we need to approve the application, that application will be rejected, and then a valid reason will be indicated as to why the application was not approved.
I see this one. I am not quite sure this one if it's relevant to this session, Tommy. How can I use my name as some form of a business, meaning I can present myself as a standalone business and sell services like presenting or sell ideas to companies at a global stage?
I know this one, it
But
doesn't.
I think yeah, maybe the customer he wants to run a business as a sole proprietor. So in that case, you don't need to formalize your business. What you can do, you need to visit sales offices and then apply for a tax clearance, and then you can start doing your business. Thank you. The next question to me, I believe the executor must approve. Oh no, that's just a comment.
Yeah.
Uh, okay, and then let's see this one. Can you resign a director if the company owes annual returns?
Yeah, currently a person can resign if the application was filed online. So I think that is where we just need to get our house to order here, because on the e-services transaction, even if the company is in process of deregistration, owing annual returns, the transaction will go through. But on the manual application, the system will not allow you to proceed with the change of directors on the company if it is still owes annual returns. But on the e-services, it do allows. So I can say yes or no, because on the other side we accept, on the other side we don't. So it doesn't make good sense to me. I think that is why I'm saying we need to get our house in order with regard to this one, so that whatever happens on the left must also happens on the right.
True. And then I think this one was actually addressed that you can obtain a death certificate
Yeah, they don't
from
want to go.
Department
Yes.
of Home Affairs.
Yes.
Let's see the next question. Physical address of director is prompted per the online CR39 application. Is this the residential address or business address?
Physical address, it depends. Remember, some of the companies are being operated from the physical address. So it can be your choice whether you have got the business address separately to your physical address. So in other instances, you may find that the business address is the same as the physical address. So that is the choice of the director, how they want to operate the company, whether at a separate venue or within the residential area.
Okay, next question to me. Can the director that is resigning sign CR39 or does it give to be one of the remaining directors?
Yeah, we don't expect the resigning director to sign CR39, because the director will hand over the resignation to the company to tell them that I have resigned. Once I have resigned, I've got nothing to do with the company. So I resign and then I walk away. The company will convene a meeting whereby they are going to accept my resignation. So I don't have to be expected to come back and sign the resolution. Those who are there, they are the ones who need to sign the documents.
So this one also, I think, is also addressed, this one of director removals, and then the information is also available on our website. You may also check our notices, and then even the step-by-step guides is also available on our website. And then even this recording will be available on Facebook or YouTube. Thank you. Then this one is this the next question is what section will be applicable to the removal of a member of CC?
Even though I'm not quite sure about the section number, but in CC, normally when a member is being removed, it is through court order. That is what I know. We need to get the court order to remove that person, because that person owns certain percentage within the business. But I'm not quite sure about the section number.
Thank you. There is a court case that says that the company does not need to give reasons for the removal of a director, Tommy.
Yes, that is true. Remember, in this case, for the removal, I've touched on that one. For the removal of a director, I said there's two processes. It's one where the resolution is taken by the shareholders in a meeting, and then the another option is the one that has been taken by the board of directors. So if shareholders want to remove a director, they don't have to give the reason why they want to remove the director, because they are the owners of the company as per the Companies Act. So they can remove the director without giving the reasons. It is their own company. Then they employ whoever they want to employ. So they can remove the director without giving the reasons. But this one is very tricky, Bra Simon, and the audience. It's very tricky in the sense that if you can refer back to the Pretorius case, whereby the shareholders sought to remove directors from the company, and they gave the directors notice of the intended resolution. And then subsequently, at the shareholders meeting, the shareholders voted to remove those directors, you see. And then, however, those directors who have been removed, they challenged their removal on the grounds that the notice that it was provided to them was faulty. It didn't indicate the reasons why they are being removed as the directors. So I remember the Western Cape High Court found that the removal of the directors was invalid because the notice was faulty, and then it did not comply with Section 71 of the Companies Act, whereby the Companies Act says the director concerned must be given a notice of the meeting and the resolution, and the director must be afforded a reasonable opportunity to make a presentation in person or through a representative before the matter is put to a vote. So in this case, the court held that the requirement that the director be afforded a reasonable opportunity to make presentation in terms of Section 71 of the Companies Act mean that the shareholders are required to furnish the director's consent in advance with reasons for the proposed removal. And then this will enable the directors to make proper presentation at the proposed meeting because they know exactly what is the charge. Then they went to the meeting well prepared. So out of that case, there was no appeal against this judgment, and the decision by the Western Cape High Court is binding in the Western Cape. So the shareholders just need to be cautious when considering the removal of a director and take note that a director is entitled to be furnished with the reasons for his proposed removal.
Thank you, Tommy. And then this one, disqualified directors, is it the register uh, easily accessible, available to the public? And then your guidance in this regard is appreciated in advance. Thank you.
For that one, I'm not quite sure if this register is accessible to the public, but in most cases, I normally receive emails whereby a person will be complaining about the director who has been disqualified. They give us the ID number, and then we just send it to the department where they keep this register to verify the disqualification of that person. But I'm not quite sure if maybe the member of the public are able to access that register. But if they provide the ID number of the person in question, then we can be able to give the response on the disqualification of that person.
Thank you. The next question is, what procedure to be followed where a director has been appointed without his or her knowledge? This could be a fraudulent action by the directors who appointed such a director. The person only learned about the appointment subsequent to receipt of a SARS notice.
Yeah, the remedy that we have with regard to this kind of appointment is through Regulation 168 of Companies Act, whereby the transaction or the filing can be challenged within 10 business days after the change has been registered. So by filing COR 168 and send that document to director objections at cipc.co.za to challenge that transaction. Once we receive that objection form, then we will reverse that change and put it back to where it was before that transaction was approved. So the remedy is there. If there is a fraudulent appointment or fraudulent transaction that was not authorized by the company, then you can file an objection by submitting CR 168, and then that transaction will be reversed.
Thank you, Thomas. Now, the next question for the change of directors in an external company. Is it mandatory to have a resolution from the South African branch entity, or will a resolution from the parent company suffice? Thank you, Tommy.
Yeah, remember that external companies are not recognized by the Companies Act. So whatever change that need to be made in that type of a company, it will have to comply with the CIPC regulations, not with the Companies Act, because this type of a company is not recognized by the Companies Act. So when they file the change of directors, they will have to comply with the requirements within CIPC, like the resolution will need to be submitted, because this one is not required by the Companies Act, it is required by CIPC. So we will need the resolution. It can either be from the South African branch or from the parent company, as long as the resolution is there to confirm the change of directors, then that one will be acceptable.
Thank you, Tommy. This one, I don't think it forms part of director changes, but yeah, the
No,
customer wants to know, can he own subsidiary company?
no, that one, I don't have an idea about this one. How can a company
Yeah.
own subsidiary company? No.
Yeah, but remember with this question, many people will ask you, but we don't have any registration of a holding company, or in most cases is whereby a customer will actually register a company, whereby we will have different companies. And then, so when you have these many companies, obviously they will appoint a holding company, it becomes a main company. So now
Mm,
all these small companies, they actually support the main company, and then in that case is a subsidiary. So but in most cases is this question they keep on coming, and then if we have a registration for holding company and so forth, we don't have that process. The process for registration of company, obviously we have non-profit and profit companies, and then the information is also available on our website. If you need more information, should you have any query, you can always check our Facebook guys. They are consultant them, and then they will be able to assist you, or you can always call our call center, and then they will be able to assist with the questions that are not relevant for this session. Thank you very much. And then now um, the next question is I just submitted a COR 39 signed using digital signature via DocuSign. This was rejected, stating type signature are not allowed. Please advise as to why this was rejected. Thomas?
yeah, that one, I think it was not supposed to be rejected because electronic signatures are also acceptable. We don't only need the manual signatures, the typed signatures. Even if it's a electronic signature, then that one is acceptable. So
Thank
maybe,
you.
which means it was incorrectly rejected.
Okay, this one, director changes is free of charge. So there's no charge for director
Yes, there
changes.
is no chargeable fee. Yes, that's true.
The next question, we have a CC which needs to remove two deceased members. No death as certificates are available. How do we get this passed? We've indicated that this one can be obtained via Home Affairs.
Yes, that's correct.
And
And
then the
furthermore,
same as, yeah, good morning. How do I remove a deceased member of a CC?
yeah, as I've indicated, we need to get an executor need to be appointed to come and manage the estate of the deceased, which means that that person is the one who will also sign on behalf of the deceased that the person is no more. So the executor is the one who will come and run the show on behalf of the deceased.
Thank you. And then what are the implications on credit agreements when directors change? Do you have an idea, Tommy?
Implication on credit agreements. I'm not sure about
Yeah.
these credit agreements.
Because
What?
I don't think that when it comes to credit agreements, CIPC is not that
No, CIPC is
involved
not
or doesn't
involved.
have control over them.
Yes,
The only thing that we assist is the process of actually, if you remove or resigning a director. I think that's where we come in. I
yes.
don't know. I don't know. Maybe you may assist to me.
No, you are quite right. We don't have control over this because if there are some agreements with regard to maybe transfer costs, something like that, so CIPC cannot be thrown into that issue because it is between the directors themselves, unless if maybe they can have to refer this to court just to get determination, proper one.
Okay.
Yes.
Thank you very much. And then, what do you do if you cannot contact the director to be removed? I don't understand this one.
I think this one is the same as the one that I've already responded that the person is nowhere to be found, and then maybe it's blocking the day-to-day running of the business, and then the company is not able to operate, and
Mm.
then now they feel that they want to remove this person. So I've indicated that the company can pass a resolution to remove that person because they can't get hold of that person, and then they also need to give us an affidavit stating the reasons why they cannot provide certified ID copy of that person. Then it's then
Thank you.
that we can be able to remove him.
And then I think even this one you've actually
Yeah, we
addressed
have
this one
already
already.
addressed this
Right,
one.
right.
Yeah, they don't have
Okay.
to sign. Yes.
And then on SCC, it sometimes take very long to receive a letter of executorship when a director passed on. What can we do to change the directors in specified time?
But here now they are referring to two things because they said on a CC it's sometimes very long to receive letter of executorship. I think maybe it's when a member passed on. What can we do to change the director in the specified time? Unfortunately, we cannot do pre change of directors before we receive the necessary documents. We cannot do the changes now and then expect the people to submit the necessary documents at a later stage because what if they don't even brought those documents and then you have already updated your records? Then you won't have the reasons why you have updated this change. So they better wait up until they get the necessary documents from the Master of High Court, and then they can file the change of directors to CIPC with all the necessary documents available.
Thank you, Tommy. This one, a quick one. Are there any additional documents required of the companies appointing a foreign director?
No, there is no specific requirement except that we will need the passport number, which is still valid from that director. And then that passport need to be certified uh, as a valid document.
Thank you very much. And then this one, how do I remove a director who is refusing to resign when there's only two directors?
Yeah, this one, Brasai and the audience, in terms of Companies Act, in a case whereby the company has fewer than three directors, um, in this situation, I think it's under. If I'm correct, I think it's under Section 71, subsection 8. If a company has fewer than three directors and one director decides to remove another director, that is not possible. So such a matter should be referred to company's tribunal for determination. So no director can remove another director if there are two in a company. So such matter need to be referred to company's tribunal. The change of director can only happen if the other director voluntarily resigned as a director and is not being removed. But if it is based on the removal, such matter should be referred to company's tribunal.
Thank you, Tommy. The next question is
How do you go
how
about that one?
removing a director? Yeah.
But the other director refuses the resignate other is in a way that does. No, in this one, it's a situation whereby Maybe somebody wants to resign because he is running away from some of the things, wrong things that he did in the company. So maybe you find that the directors, they block his resignation because they've got some reasons. So I think this matter cannot be addressed by CAPC. This can be taken to court so that a proper determination can be made as to whether this person need to be kept as a director or should be released as a director of the company. But CAPC cannot play any role in that regard.
Thank you, Tommy. And then the next, how long does it take to approve the resignation of a director considering all documents submitted?
It depends on the type of application that you submitted. If it is manual application, then the turnaround time is 3 days. And then if it's e-services, then it's 2 days turnaround time to finalize the application.
Thank you. When submitting a CR39, are you required to include share certificates and its respective register? These have been instances where applications have been rejected due to a certificate not being included, whereas sometimes it is approved.
No, if it is approved, it means that it was incorrectly approved, because whenever the resolution has been taken by the shareholders, the share register certificate is required, which is certified, because as I've indicated, we don't have a record of shareholders at CIPC. So we won't know who took the resolution. So that is why if they indicate that this is the shareholders resolution, then we will need the share register certificate to prove that the shareholders are 1, 2, 3. These are the ones who took the resolution. But if it is a board, then we will need the attendance register of the directors who attended that meeting.
Thank you. The next question, and then is good day. We have done several director removal applications, but every one has been rejected for different reasons. The removal is for a non-profit company, and the directors no longer has interest in the company.
Yeah, it's very difficult to tell on this one because I don't know the reasons for the removal of those directors. So whether the reasons were highlighted or they were not highlighted, it is not clear here. But whenever the director is being removed, the notice must indicate the reasons why this director is being removed. So if the reasons are not stated in the notice, then the application will be rejected. But if they have indicated the reasons, and then that this is the reasons why the director is being removed, and then in the meeting the person has been voted out, this is the resolution that has been taken in the meeting to remove the director, then there is no reason that the director cannot be removed.
Thank you, Tommy. Upon a resignation and appointment, CIPC requested that all directors, including the appointed and resigning, must sign the resolution.
Yeah, in this case, we only need the signatures of the incoming director and the outgoing director. In case it's a simultaneous change, whereby one director is being appointed and then the other one is going out, then we need both directors to sign the resolution to confirm that they agreed on this transaction, because one person may come back and say, "Oh, I didn't sign anything, but I'm no longer a director. How did I be removed from the company?" So in this case, where there is incoming and outgoing, both of them must sign the resolution.
Yeah, the other question is, which document do I need to remove a single shareholder and replace with a new single shareholder?
No, we don't appoint or process the change of shareholders at CIPC. These shareholders, it is done by the company itself. We only process the change of board of directors, not shareholders.
So now, if a director was fraudulently removed, how does the reinstate himself?
As I've indicated, you need to object by filing COR 168 so that that change can be reversed, because it was not unauthorized. It was not authorized, I mean to say.
Thank you. From Mandy, if there is a sole deceased director of a PTY, we have that certificate but no executor letter. Can the shareholder sign the resolution and minutes to make the changes, please?
Yeah, remember here now they are talking about the sole share director, but there are the shareholders within that company. So if the shareholders are there, then the shareholders are the ones who will do all the process of change of directors.
Thank you. The temporary ID document has been declined before. Can we perhaps then just inform your team to accept the temporary ID documents? Thank you.
Yes, that's correct. The temporary ID from Home Affairs, it's a valid document that is acceptable.
Next, what documents are needed to direct a shareholder's appointment?
Uh, no, we don't appoint the shareholders at CIPC. We only appoint the directors. So there is no document to appoint the shareholders.
Yes, I think this one also was actually addressed. Let's see this one. Is there a standard rate to charge for resignation and filing of companies on behalf of other people?
Is there a standard rate to charge for
N-
registration and
No,
filing of? No, no.
no. Remember, CIPC. Let's just maybe talk about the third parties. We don't have third parties at CIPC. We our services are accessible, are available on our website, and then we also have walk-ins and then and other partners, and then the addresses are also available on our website should you require more information. So we don't have third parties as CIPC. And then the next question is, we have recently submitted a director change, and minutes also declared the shareholding changes. Those share transfers are internally dealt with by will CIPC request a shareholding certificate? I think you also addressed this one to me. I don't think that
Yeah,
we
we
should
also
go
address
back.
this one now. This one is with regard to the shareholding. So I think we have
Okay.
already touched on that one.
The next one is, if you can't get hold of directors or have ID copies for them, how do you take them off as directors?
Yeah, as I've indicated, we'll need the resolution of the company signed by all active directors, and then they will also need to provide an affidavit stating the reasons why they cannot provide the ID copy of that person.
Okay, the next one of only two directors absconded, but it's refusing to resign as a director. Both directors are also equal shareholders. How do I remove such a director?
So, as I've indicated, if the company has got fewer than three directors, no one can remove the other director. So they better refer this matter to company's tribunal for proper determination.
Okay, so what is the practice number 42 of 2019 for removal of directors?
I think this one it deals with the requirements for the removal of director, even though I don't have this practice note at hand. But if you can check on the website, you will see all the details that has been listed on that practice note.
When submitting director amendments, are you required to submit a notice of meeting and mandate to lodge?
No, remember it will depend on who is filing the application. If you have appointed somebody to file the documents on behalf of the company, then there should be a mandate. But if the company or the directors themselves file the change of directors, then they don't need to submit the mandate.
Okay, let's just
But
some of
the
the
notice of
questions we address them. This one,
yes.
is it still a requirement to provide a power of attorney for a third party to lodge CR 39?
Yeah, you need to, if somebody, a third party who has been authorized to sign on behalf of the company or of the directors, then the power of attorney will be required.
And then this one of triple BEE, if the director changes while BE certificate is still valid, how do I get a new certificate? So, but I think we have that manual one on CIPC website. You can just download a copy, as, fill it in, go to a commissioner of oath, and then let me them sign until is the original one expired. Once it's expired, and then is then you can apply for a new triple BEE.
Okay, no, thanks for that.
Uh, can a director of a deregistered company be? No, it cannot, because I mean the company is deregistered. Let's see this one. For clarity, if a PTY has 3 directors and one is deceased, then only the deceased director ID and death certificate is required with a resolution COR signed by the current directors. This would mean the executor documents or signature is required for the change. Kindly confirm.
Yeah, in this case, remember this person is not the sole director. There are three other there were 3 directors and then one director is passed on. The remaining directors are the ones who need to sign any documentation with regard to the recording of this person who passed on. So we don't
Okay.
expect the executor in this regard because there are active directors within the company. The executorship letter will only be required in case the director was a sole director and a sole shareholder, which means that after he passed on, there is no one left in the company.
Okay, this one, they are also requesting email address, but I will actually refer you to our website. Go to 10 around times on our website. That's where now you'll be able to find these email addresses where you can escalate a matter if it was not resolved in the office. Thank you. Please clarify, we as the board of directors, we were also requested to submit the shareholder register certificate.
I think they need to check how they have drafted the resolution. I mean, how they have drafted the resolution or minutes of the meeting. If they have indicated that the resolution was taken by the shareholders, then the share register certificate will be required. But if it is by board of directors only, then there is no need for the share register certificate to be submitted.
Thank you. I have experienced that even director resolutions signed by majority, but not all directors are rejected. I don't know this one.
No, remember in this case, the resolution need to be signed by at least 50% plus directors. If maybe the company has got 3 directors, at least 2 directors can sign the resolution, not only one director.
So now this one to me said, I'm finding it difficult to remove myself as a director for a company. I'm leaving. How does the process of removing a director look like, and who is supposed to do this on CIPC? But this one must, I think it must actually apply for a deregistration.
No, not necessarily deregistration. I think what this person need to find out is how to resign from the company. So my response to this one is that remember that a director is appointed by a company. And then when the time has come for that director to resign, that person must hand over resignation letter to the company that employed him, together with the certified ID copy, so that the company can prepare necessary documents to be filed with CIPC so that we can remove him from the register of the company. So he needs to
Okay.
resign with the company that employs him by submitting the resignation letter.
Okay, thank you very much. How do we remove a director who is also a shareholder, but he has gone overseas and is no longer contactable? About how for we change the whole shareholding. He is not sound around anymore to sign.
Yeah, this one is a bit tricky because the director, he is a director and he is also a shareholder. And then now, I don't know if he is alone and then he is nowhere to be found. Who is looking for him? Because he is the sole owner and then he is the sole director at the same time. So I don't find it clearly how do I have to deal with this one, because I don't know who wants to remove him because he is the sole shareholder and the sole director. Who is worried about this business?
Okay, maybe
Yes.
Thomas, for the benefit of those who were with wrong rejections, may you please just provide your email address. Just write it on the chat so that they will be able to reach you.
To write my email address.
Yes, or
I just wrote it down. Yeah.
okay. Yeah, while you are talking, the next question, because time is not on our side now. I would like love what is that thing now? What's the next question? Okay, I would love to change the name of my NPO as well as directors. I already have certificate from social development. Do I make changes with CIPC or social development? No, I think in this case, it is registered with a Department of
Yeah,
Social
social
Development.
development.
So
Yeah.
please just go to social development and then address this matter with them. And then foreign director, the services platform does not allow for foreign cell phone numbers. This causes problems with OTPs. Please advise best way forward. Tommy?
Yeah, unfortunately, the system has been designed to take only South African cell phone numbers, not for the foreign directors. So I
Yeah,
think yeah,
yeah. I also think that's why maybe in terms of the act is that if you have foreign company that you need to have a address for service in South Africa where they will be able
yes,
to,
so
or where
that you
you
can
can
be
be
able to,
contactable. Yeah.
yes, so that
Okay.
they can be able to contact you.
Thank you very much. And then the next question is, what happens if the shareholder is the holding company who want to remove a director?
As I have indicated, that whenever the company has got fewer than 3 directors, and then one director has to be removed, then such matter should be referred to companies tribunal.
Thank you very much, Tommy. What is the reasonable time to give directors for the removal meeting? I don't know this one. Can you say something on this
Maybe
one?
it can be at least 10 days to prepare for a response in the proposed meeting of the shareholders or the board of directors meeting.
This the next question. Let's just quickly check this one. MT ex-wife does not want to sign out and she has never been active on the CC, and now I'm stuck. I can't work now because the business bank account is closed and she needs to sign. I've tried for 5 years and I'm still paying the returns on CIPC, CIDP and SARS, the closed corporation in good standing. I've made sure that, so I'd like to know how to solve this problem. She has her own company that is she registered in 2015, just before a divorce. Any
Yeah,
comment?
this one, yeah, for this one, I think they can get the court order that will instruct CIPC to remove that person as active director of the business.
Okay. I think this one also it is about shareholding. We don't keep shareholding information.
Yeah, we don't keep
Uh,
the record of the shareholders at CIPC.
how do you remove directors that are owl and refuse to sign the documents to attend meetings?
Yeah, as I've indicated that we need to get the company resolution stating the reasons why they want to remove those people. And then they will also have to provide an affidavit stating the reasons why they cannot submit the certified ID copies of those guys. And then after we have received those documents, then we can be able to process the removal of those people.
The other question is how do I remove a director who has a foreign death certificate?
As long as we have got a proof of death for that person, then we will record that person as deceased on CIPC records, whether the certificate is from abroad or is within the South African borders.
This is about triple BEE. Um, I don't think this one is for this session. Please
Yes.
direct your question on CIP Facebook, or you can even call our call center to assist you. Thank you. How do you go about removing a director that wants to resign, but the other director refuses the resignation? The director refuses the resignation, is claiming the credit score of the other director.
Yeah, as I've indicated that sometimes the reason for his resignation might be running away from something wrong that he did in the company, and the other companies are not happy that they are the ones who will now be responsible to face all the problems that he created. And then in this case, they can refer the matter to court so that they can get proper advice with regard to this.
Hi, please confirm what documents are needed for director appointment to the board by the company's shareholders in addition to director's resolution. SUR 39 consent letter ID. What shareholder documents are needed by CIPC? Tommy, you.
Yeah, what is required for the appointment of a new director by the board? It will be the minutes of the meeting whereby the decision was taken, and then or the resolution confirming the change of directors, and then they will also need the SUR 39 as they indicated. The consent letter is indicated. The ID copy of the person who is affected by the change. In this case, it will be the new director will be required. Then those are the documents that we will need in order to appoint that person as a director and not as a shareholder.
Thank you very much. If a director resigns from a company having 4 directors, do we need to forward certified ID copies for all of them?
No,
I
no, we
think
need
you
the
you you,
yeah, we
you
touch
addressed
this one.
this one.
Yeah, for only that
Let's
one who is
let's
resigning.
take the last one. When an application was incorrectly rejected, does a new COR 39 need to be generated? This shows down the process and reflects negatively on third parties assisting clients to do director amendments. Do you have any?
Yes, unfortunately, I understand this frustration because it is not created by the client, it is created by CIPC. But unfortunately, in order for us to process that application, we will need the new tracking number because the previous one, we cannot use it anymore on the system once the application has been rejected. We will need the new tracking number, unfortunately.
Thank you. What if you don't know who the executor is for the director that passed on?
In this case, the executor normally is appointed by the deceased while he is still alive. That information can be obtainable from the will of the person who died, or if there is no will, then the Master of High Court can appoint the executor who will manage the estate of the deceased.
This one, I think, is just saying that. So for me to remove a director in terms of resignation, do I still need to follow the steps for the removal and resignation? Yeah, yeah. You just need to follow this, and then let me just say this. All this information is available on our website. You can check the step-by-step guides. They are available on our website. We also have notices on removal. You can check. You can check this presentation. You can even request it from our education at cipc.co.za email. We'll be able to share the slides with you. And then for the recordings of this webinar will remain on Facebook and YouTube. Should you wish to view it again. And then the other thing, if we by mistake we skipped your question, you may direct that question on our CIPC Facebook. You can inbox us. Our call center are there. If they cannot answer you, obviously they will refer to the relevant division to address it. And then we also have our call center. And then you can always ask them any question or questions that are related to this session today. And then I just wanna thank you because we are now uh,
Maybe
coming to the end of the presentation. Let me give you a chance, Thomas, to say something. Thank you.
okay. Maybe before you wrap up, Brasai, I see one question here that is very much important. That sometimes a director wants to resign because he is not happy with the conduct of other directors, and not because he has done something wrong. How then
Mm,
does he resign if the other directors refuse to accept the resignation? This question is very much important because remember, I
mm,
have indicated that once the director decides to resign, he must hand over resignation letter to the company together with the certified ID copy so that the company can file necessary documents within 10 business days. Failure to do that, it means that the company has contravened the Companies Act. And then the affected person, if after 10 days he find or she find that she is still listed as the active director, whereas he or she handed over the resignation letter, then that person can lodge a complaint to CIPC by filing COR 135.1 form to complain that I have resigned. Here is the proof. I handed over my resignation letter to the company, but the company fails to record me as a resigned director from their business. Then CIPC will have to enforce that company to comply with Companies Act because the director has resigned and then handed over necessary documentation. He don't have to give the explanation why he is resigning. He is resigning because maybe he want to pursue something else. So no one should block the resignation. So if he resigned, after 10 days, the company failed to comply. And then by doing that, that person can now lodge a complaint to CIPC by filing that CR 135.14 so that the company can be forced to comply.
yeah. Thank you very much, Thomas. Is there anything that you want to say before we
No, no,
close
that's
the
all.
session?
I just saw this question and then I realized that we are wrapping up. Maybe we cannot cover it.
Oh, okay.
Yeah.
Thank you very much. Thank you, Thomas. Thank you, Rosanio. Ladies and gentlemen, we have come to the end of the webinar. We hope you found today's webinar of value and that it will assist you. Thank you for joining our webinar and have a good day. Thank you. Bye-bye.
Thank you so much. Goodbye, colleagues.